Our next speaker is Emily Rome. Emily is filling in for Nicole Narotsky. Emily is from the Maslon firm in Minneapolis. She is a partner in Maslon's litigation practice group, successfully representing businesses in complex commercial disputes, including product liability claims, business torts and fraud actions, and breach of contract claims. Emily represents large and small businesses in all forums, federal and state courts, mediations, and arbitrations. Emily was named one of the top women attorneys in Minnesota and recognized as a Minnesota Rising Star. Please welcome Emily Rome.
Good morning. This will be really exciting. I have 25 minutes of protective order clips. So let's roll. No, I don't. That would be horrible. I'm sorry. All right, good morning. Let's imagine that we're in contentious litigation. There's a protective order in place with an attorney's eyes-only designation. Your company has produced thousands of documents, and you come to find out that those attorney's eyes-only documents have been disclosed to your competitor, the other side, to hundreds of their internal employees. Nightmare, right? Also, recently in the news, the sanctions order came out at the beginning of this year in the infamous Apple versus Samsung litigation. Let's talk about what happened. You have a junior associate, it's like a movie. You have a junior associate working late at the firm, redacting the attorney's eyes only information out of the expert report that Apple produced. The way the litigation was set up was that because it was such a gigantic fight, as we all know from the press on it, Samsung had set up internally an FTP site where key documents were uploaded so that globally employees could be kept up to speed on the litigation. So poor junior associate is tired at night, misses some of the designations. The inappropriately redacted expert report is uploaded to the FTP site, and in the subsequent 3 to 10 days, downloaded and emailed around hundreds of times. It contains key pricing information on Apple's contract with Nokia. This later comes to light because in Samsung's negotiations with Nokia, they say, Samsung says, well, we know what the terms are that you have with Apple, and of course, complete chaos ensues. There are multiple hearings on the subject, there's discovery on this, and essentially what happens is, we can all agree, nobody wants to be Apple, right? Now Apple's stuff is out there, you can't unring the bell. Nobody wants to be Samsung or Samsung's attorneys. They are sanctioned, they're publicly reprimanded, and they're sanctioned, they have to pay for all the fees and costs for all of the hearings, all of the discovery, everything related to this issue. Here's what's important and what resonates with me as we look at this and we think about where we are in the litigation that we have, the volume of the documents that we all experience now. Here's what the judge said. The court reprimands Samsung and, as I said, sanctions them, of course, for failing to disclose. Oh, by the way, this happens. They never tell Apple until this comes out in later negotiations. So obviously, big no-no number one, nobody here would do that. But listen to what the court said. I'm also going to sanction you for failing to have in place a team member to track confidential documents and information and how that's being sent and received, and for your failure to have in place a better process for rectifying mistakes, particularly given the nature of modern litigation. So think about that, how that relates to a protective order and how you have to align yourself in that work. The court says about the associate's mistake, even if regrettable, and nobody really blames the associate. We all know these things happen. We have to have a structure built to deal with them, and that's what I'm going to be talking about. But the court's quote is great in referencing the associate's inadvertent mistake. Even if regrettable, these things can happen and almost certainly do happen each and every day. But when such an inadvertent mistake is permitted to go unchecked, unaddressed, and propagated hundreds and hundreds of times by conscious and indeed strategic choices by that associate's firm and by the client, more significant and blameworthy flaws are revealed. That's what we want to try to avoid as we think about protective orders. All right, so let's get some basics down. Rule 26 obviously governs here. We all know that. You can have good, if you have good cause, you can get a protective order to protect sensitive trade secrets, confidential financial information, right? Good. Various state courts have mostly mirroring standards, but some with obviously some differences, so you need to be aware of what the state standard is if you're there and not in federal court. Keep in mind that a lot of courts have gone to a place now with the electronic discovery and just sort of with everything that's happening in our practice now of having standard POs that they require at least that you start from, so certainly look there for that with a lot of courts. One thing that's important to note here, while you need only good cause to get the protective order in place, you're often going to need a higher standard. A court's going to have compelling reason must exist to seal those documents. So you're going to have one standard to get it, but if you want to then use and protect by sealing, you may be facing a higher standard. So obviously be aware of that. All right, so what am I saying here? Many of us, myself included, protective orders, not necessarily the sexiest part of our job, but nonetheless an important part of our job. So the case comes in, you reach for a PO that you're familiar with, that you like, one you like a lot. But of course, what I'm saying here is just don't do it by rote. Customize and think about a couple areas where you want to be making conscious decisions here. Because of course, different documents, different cases, you all know that. One behind there. All right. The goals and considerations here are obvious. The whole point is we want to protect things. What I actually do is have a short checklist for yourself, whether it's at the front of your template PO that you use or just somewhere that you can access easily, just to quickly remind yourself. You don't have to spend hours and hours. That's not what I'm suggesting. But I am suggesting that you just quickly tick through, okay, with this case, what are the tiers should I have? How should I deal with the clawback, et cetera? So just have that quickly there for yourself. Has to be workable, and you have to make it so the court will enter and enforce it. As with all the topics today, we could talk about them for much longer than 20 minutes. So we're just going to hit today on 4 things that we can focus on. Sharing provisions, inadvertent disclosure and clawback, sealing, and then post-litigation obligations. What do I mean by sharing provisions? What I mean is, I'm defense counsel, I send out my draft PO, and it basically says, confidential documents in the case can only be used for this case. Neat, tiny, here we go, tight. What you get back is a fascinating red line that says, they can be used for this case, or similar cases, or similar products, or to give to my friends on the other coast who are having cases also against your company, is basically what it looks like to me when I read it. All right, so that's a sharing provision. Plaintiff's counsel says to you and to the judge, well, this is wonderful. The federal rules are for increasing efficiency and decreasing cost, and this will do that. So we should have this sharing provision. Sometimes they'll even acknowledge what they really want to do with it is to use it to pursue future cases and other wrongs and whatever, but not often. As defense counsel, I almost universally strongly oppose these. And there are certainly instances where it will make sense, and I'm talking about one-off cases. Obviously, when you're dealing with an MDL or something, that's a whole other ball of wax. But I'm talking about one-off cases. So, what are the reasons for not allowing it? Obviously, you lose total control of your documents. They become the arbiter of what's relevant. They're giving it to whomever in the same case or similar or whatever. And how do you know if that's even relevant there? It may not even be discoverable in the other action. So obviously a whole bunch of huge problems here, and usually is a general idea to fight these and not allow them. There's case law, however, going both ways. So the majority of decisions you'll find do not allow the sharing, but if you practice here in New York, there are a couple decisions you're going to need to distinguish because there are a couple from the federal courts here that do allow the sharing. All right, second big issue, inadvertent disclosure of privileged information. 2 key federal rules on this, Federal Rule of Evidence 502B, and then FRCP 26B5B. 502B basically says the production of privileged information is not a waiver if it was inadvertent, There were reasonable steps taken to prevent the disclosure, and then reasonable steps to rectify the error. That last part, reasonable steps, also then loops itself down into FRCP 26 because it references that rule as well. What are some interesting things here and things you need to think about? Obviously, this is really jurisdiction specific and fact specific to your case. Things that the court is going to be looking at include, when you're analyzing under 502, all the things that you would think of, but some kind of tending toward the more modern angle of litigation. So what precautions were taken on the front end? How much time did it take to rectify the error? What was the scope of all discovery in the case? How big was the document production? What were the pressures in getting that document production out? And the time constraints. And a big hot topic in all our lives, what was their analytical software or search terms used? How did that all play into it? And then, of course, because it's courts, they throw in the overall fairness consideration as well. So all these things are going to be balanced out. Interestingly, when you go down to FRCP 26, that flips the perspective, and now you're looking at it from the perspective of the receiving party. So if you are notified as the receiving party, you then have certain obligations under Rule 26, which you're probably all familiar with. You have to return it, you can't use it, you gotta get it back from any experts or anybody else you gave it to before you learned, and then of course you can dispute it if you desire that. And everybody has to preserve everything in the interim. So these are the rules that govern it. Well, so what should we do? What am I advocating here? What are some best practices for clawback agreements? First, in this day and age, with the volume of what we deal with and the complexity, I'm suggesting that you should have a clawback in almost every protective order that you have. You can have them as a separate agreement. I usually have them inside of my PO. The important thing is, if you have a clawback provision, don't just have it as a stip on the side, because then in most jurisdictions it will not be enforceable against third parties. You need it to be part of the protective order. Obviously, you need to review the law in your jurisdiction because it's going to vary widely what's reasonable, what's going on. And 502, or any sort of analogous state law, that's going to govern unless you explicitly, very explicitly, in your PO, set out how you want to do it instead. So you can define what inadvertent disclosure means. You can define what reasonable means, protection both on the front end and reasonable to rectify. And if you're going to take the time to do that, it's important to do it. So you may say, it's reasonable to use the following search terms, it's reasonable to do X, Y, and Z. As you can see, this is going to tie up a lot with your ESI. So as this is happening at the beginning of the case, you need to be thinking about your own production and your own electronic stuff and what's possible and what do you want to agree to. Obviously, don't get sloppy. Even though you have these, some parties, based on volume, you can imagine, millions of documents. What they want to do is put in the PO basically a no-fault provision. I don't have to take any reasonable steps. I'm just going to give stuff, and then I still get to claw it back. I think that has some practical problems and risks in it, but you should also know that there are a number of courts that reject that approach. So be careful if you want to take that no-fault approach. And again, establish the procedures for invoking it. How is this going to get kicked off? Make sure that that's in there. And then in complicated cases, you may want to have a provision that deals with clawing back testimony that may have related to those documents. You're going to have an intersection here with the ethical rules. You can see 1.6, comment 18. Lawyers have a duty to competently safeguard from inadvertent disclosure. You can see the factors here that you would expect to see. More interesting, frankly, to me is Rule 4.4b. Here's why. It is in tension with FRCP 26. So now FRCP 26 says if you're notified, you have duties. The model rule 4.4 says you have duties, whether you were notified or not, if you knew or should have known that this was an inadvertent disclosure. Interestingly, 10 states have not adopted 4.4, and I actually got into a fight with somebody. I had a provision, and they said, nope, not in Ohio, not my duty. Too bad. So you may run into that fight. But my point is, the ethical rules require it. You may as well, the federal rules require it. Given that we know we're all in an age of tons of discovery and electronics and technology changing. Why shouldn't we plan for it? Make a plan for it in your PO. Develop a structure that you can live with the facts of your case and the way that your data is structured. And then make sure, back to the Apple-Samsung judge, align your team with it. Don't set up an FTP site to blast it out globally. Great idea. But what they should have had was some kind of check system to make sure that those documents were ready to go. And that's why they got in trouble. They didn't. You can do that, but you have to have more protection built in if that's the way you're going to live. If you're going to leverage the technology to blast it out, then you better have the protections there. All right. Moving on to the third important issue, sealing documents. All right, so now you've got all this confidential stuff. Maybe it's tiered of different kinds. What are you going to do? How are you going to then use it in court? If you've not run into this already, the judges and their clerks can get really cranky about sealing stuff because it creates a lot of extra work and rules that they have to follow. So make sure that you're checking not only the local rules, but you're getting your boots on the ground with respect to that particular judge, because this is going to be very specific even to the particular judge within a jurisdiction. But make sure as you're setting this up, you're following, of course, the rules there. But, you know, don't hamstring yourself. Don't make it so, unless the local rule says you have to do this, don't say, yes, wonderful, and they'll file their motion and I'll have 2 days to respond. Or, I mean, build in reasonable time frames if you're going to take the time to have this whole setup. Because, as we all know, that may not be enough time to figure out how damaging it is and how hard we want to fight and file a brief and all that. So that's just a practical consideration that we often forget in our effort to be efficient. All right, and then finally, post-litigation obligations, some best practices here. Make sure that you're ensuring that your protective order remains enforceable post-litigation, that you're going to have a clause that the judge still has jurisdiction to enforce that. And then we all have these things in there. And then 60 days after, you know, the final settlement or last appeal or whatever it is, and everyone's going to destroy everything and do the affidavits and whatever. Be honest, don't raise your hand because you're all going to lie. Sometimes people forget to do that. So make sure you're following up and doing that. And importantly, so do it on your own side, but gall darn it, make sure the other side does it for you, for your client. And not just them. What experts did they give it to? In lots of industries, the experts are going to be basically from competitors, right? So make sure that stuff is gone. And don't just worry about the paper. Again, back to the ESI stuff. Think about when it's going out on the front end, where are they going to store it? What if it's a whole bunch of data and it's on their server? Guess what? Servers get backed up. Where's that stuff going to live? We have to think about those things on the front end, or we think we've destroyed it and we haven't. So just a couple, dipping our toe into protective orders, a couple things to think about. I'm between you and the break, so that's it.